give me a sense of, you know, where you're coming from with these filings, um, for those who see this and ask, why should Jennifer Crumbley be released? What's your answer?
Well, I mean, simply put, Miss Crumley did not commit any crime. And, as much as I hear people talk about how there's never been a case like this and that this is the first case of its kind in the country, I mean, that may be true, but there's a good reason for it. The reason it's the first time is because, no elected or appointed prosecutor has to date attempted to criminalize, the actions of somebody's minor child who intentionally commits a crime. I mean, this is really no different than, even like let's talk about the Jenny Jones case. If you remember that back in the early 2000s, and during the 1990s, the Jenny Jones case, they conducted a show where the guest showed up and revealed a secret crush on one of his friends. And then after they left the show a few days later, the friend who was surprised by the crush went and shot his friend, killed him. As a result of that murder, there was a civil litigation that came out of that was tried in the Oakland County Circuit Court. Mr. Feiger tried that case and to a verdict, and he received a $20 million plus jury verdict. And the whole thing was thrown out, and it was thrown out for the simple reason that the Court of Appeals had said that, look, people don't have any legal duty to prevent other people from committing crimes. That is the law. That has been the law in Michigan as well as every other state. That has been the law for hundreds of years. It has never been the case that someone can be held criminally responsible for the acts of another person, whether it's a son, your sister, your daughter, your dad, family members. That doesn't change the equation. Just the mere fact that you're a family member of somebody who committed a crime, it doesn't make you liable for what they did. Absent you being actively involved or participating in that criminal act, in which this case, there was no such evidence of that.
Okay, and let me ask you one other thing. The prosecutor's office has said that there was a fair trial and 24 jurors all reached the same conclusion in the matter of Jennifer and James Crumbley. What do you say to that?
Well, it wasn't a fair trial because the jury was deprived of key evidence that could have made a difference to the verdict. I mean, the two prosecution witnesses were the two key witnesses testified on behalf of the prosecution, and they had cooperation agreements that was never disclosed. I mean, it's so elementary. Even a first-year lawyer or even a law student will tell you that the prosecutor has a duty to disclose any and all favorable evidence, which includes cooperation agreement with key government witnesses. So, that didn't happen here. So, while the prosecution can talk about how 24 jurors, considered these cases, they're also not telling you that those 24 jurors were deprived of key information and key evidence that was deliberately withheld from the defense. I mean, those cooperation agreements were not disclosed until after those verdicts were handed down. And again, these are not just witnesses who are sort of inconsequential. I mean, these two school officials were the ones who, had been under a lot of scrutiny for their own actions and failures that day and how they handled the situation. Let us not forget, those school officials told the Crumbleys they did not have to take their son out of school. So, I mean, as the professionals and as individuals trained in counseling and performing threat assessments and student evaluations, I mean, they made the professional decision that the Crumbleys didn't have to remove their son from school that day. So, to the extent that there's been a lot of scrutiny placed on them, it makes sense why they were offered these proffer agreements or cooperation agreements. And it's because they had obvious criminal exposure, and a jury should have known that, so that when they considered whether to accept the testimony of those witnesses, they wanted to believe them or not. And the jury could have just as easily concluded that those witnesses had a bias and a motive to testify on behalf of the prosecution, and they could have decided not to believe them at all. And that could have changed how the cases were decided at the end of the day.